Hi everyone, Steve Mearns here. I've been asked by a few listeners to provide a brief intro to summarize what we're going to be talking about in the podcast. Today's guest is Jenny Kwan, the Member of Parliament for Vancouver East and the NDP Immigration Critic. During the podcast, we talk about citizenship revocation, the cessation of refugee status and the automatic loss of permanent residence that results, whether war resistors should be given the opportunity or ability to stay in Canada, and Jenny Kwan's experience this summer on the Standing Committee of Citizenship and Immigration discussing vulnerable groups and the possible prioritization of certain refugee resettlement. Peter and I also discussed a recent federal court case clarifying restoration, and the three of us discussed Pokemon Go. Also, we have a website now, borderlines.ca, borderlines.ca, where you can find our contact information, old podcasts, and links to some of the things that we discuss. I hope you enjoy today's podcast. Hello and welcome to the Borderlines podcast, a podcast for the discussion of immigration, refugee, and citizenship law and policy. I'm Stephen Mearns.
I'm Peter Edelman, and we're very lucky to have with us today Jenny Kwan, who's the immigration critic for the NDP in Ottawa, a job that you've just stepped into relatively recently, and are relatively new to Ottawa as well. So this is your first session as an MP. You have some background as an MLA in Victoria, although I imagine it's been a big difference in terms of going to Ottawa. How's the transition been going?
Oh, there's no questions. That's a big difference. Definitely the scope of being a member of parliament is a lot larger in terms of the issues, and immigration, citizenship, and refugees is a very active file at the moment. I'm very lucky to be the critic in this area. I'm deeply interested in it. I'm an immigrant myself, formerly as a young girl, immigrated with my family here. And with that being said, over the successive governments, we've had policies that's been brought in place that is just atrocious. Like I'm just astounded with what the Harper government has done. And really, we need change. And the Liberal government promised change. And so I'm here to hold them account to drive those changes.
Okay, well, that's one of the things we're hoping to talk about today are some of the major changes. I think one of the big promises, and that was pretty central to the election promises, were the issues around citizenship and the changes to Bill C-24. So we saw a bill presented in Parliament, Bill C-6, which has changed a number, or brought back, pushed back or pulled back from a number of the reforms that were in Bill C-24, in particular with respect to the ability to revoke citizenship to people who've committed certain types of offenses, terrorism offenses, espionage, etc. It's also shifted with respect to residency and some other areas of the Citizenship Act. So we were hoping to talk a little bit about that. So what, in terms of the Citizenship Act, what do you see as the major issues? Let's maybe start with the positive parts of Bill C6 in terms of the parts that you think are, and I understand that the NDP was supporting good portions of the bill, so maybe we can start by talking about the things that were good about the bill.
Absolutely. Well, just to sort of, by way of background, Bill C6 was an act to amend Bill C-24. In fact, during the campaign, the Liberals, the federal Liberals, and Justin Trudeau himself actually appeared before the ethnic community and the ethnic media and said that he would repeal Bill C-24. Why did he say that? Because effectively, Harper's Bill C-24 created two classes of citizens. And so not all Canadians are treated equally. If you're Canadian-born, Canadians, you're treated differently than those who have to obtain citizenship through other means, whether you're an immigrant or a refugee obtaining citizenship. And so, that is a real issue. And so people had raised that issue during the campaign. The Liberals said they would repeal the bill. They didn't. And then they brought in Bill C6. But the thing about Bill C6 that is positive is that it did address that central issue, and it began to erase, I think, what the Conservatives have done, and that is to treat Canadians with different approaches. And so no longer that there are two classes of Canadians, if you will. So that is to say, those who committed certain offenses, you would have your citizenship revoked, versus those who are Canadian-born, that would not happen to you. So, so that's positive, and we did support the Bill C6, actually. But in that process, though, what the government's missed in Bill C6 is a whole variety of other things that they should have dealt with. So take, for example, the appeal process for people whose citizenship would be revoked. Right now, as it stands, you have more rights as someone who receive a traffic ticket by running a red light or running a stop sign than with someone who's faced with their citizenship being revoked. And there's something really wrong with that. That due process has got to be fixed, and we need to put the due process back and allow for the appeal process to be brought back in such a way for something as significant as losing your citizenship to have basically your day in court appropriately. So
just a bit of context for listeners. What the previous process with respect to citizenship revocation prior to Bill C-24, what would be involved in taking away someone's citizenship was, first of all, a referral. You'd get a letter in the mail that would say, we're thinking of taking away your citizenship. Explain to us why we shouldn't do that. And if the person was going to contest having their citizenship revoked, you would have a proceeding in the federal court, and the federal court would decide whether or not the person in fact had misrepresented or committed fraud to obtain their citizenship in the first place, which under the previous legislation was the only way to lose one's citizenship. And then there was a third stage where the governor and council, essentially the cabinet, would decide whether ultimately to revoke the citizenship. So it was a very big deal to take away citizenship. And Bill C-24 simplified that quite extremely and made it so that you would lose your citizenship. Essentially, an officer would send you a letter, say, explain to me why we shouldn't take away your citizenship, and you'd have 30 days to respond. After you made the response, the officer would then decide whether or not to take away your citizenship, and at that point you would lose your citizenship. You could then fight in the federal court through a process of judicial review to try to convince the federal court that the decision was unfair or was unreasonable, but you would be doing that from the position of not having citizenship. So,
and you couldn't introduce new evidence during that judicial review.
Correct.
And there's also no consideration for extenuating circumstances, so it doesn't really matter, for example, that you're now well settled into Canadian society, you might even have Canadian children, you're married, and all of those things that are very much part of life would not be taken into consideration.
And so in terms of the process that's being proposed in Bill C-6, have there been any changes to that process at all?
In fact, the government gapped that all together and didn't do anything about it in Bill C-6. And so hence, basically, as it stands right now in our system, people have less rights when they lose their citizenship than a person faced with a traffic fine. And that is just not right for something as serious as that. So I did propose a range of amendments with respect to that. And by the way, the Canadian Bar Association, the Canadian Association of Refugee Lawyers, for example, the Canadian Council for Refugees, and many, many organizations, individual lawyers, had showed up in Ottawa at committee to call for change and to say that this is not acceptable, this is not Canada, and you need to restore the process. And so the minister heard, I think, the issues. They said that they were going to take a look at all of this and committed, actually, that in the fall, they would bring in the amendments that I had proposed with respect to this. The reason why my amendments weren't accepted in the committee when we were debating this is because it was deemed to be out of scope. So that is to say it was out of order because it was not talked about or referenced in Bill C-6. And so when you try to bring in a provision that's not talked about in that bill, it is not accepted. It's out of order. So that's been part of the problem.
So what are your amendments?
Well, my amendments is to bring back a due process and to improve it, to not just to restore it from where it was, but to improve the process, in fact, and there are efficiencies that we can find within the system. So, for example, there are long wait times now. It's expensive for people to go to federal court, for example. So we can actually streamline some of that with respect to that appeal process. With the current system, where some of these hearings are being heard on different cases, for example, with officers that are hearing cases, that they can actually bring in the evidence and call for also for humanitarian and compassionate reasons, and to consider extenuating circumstances and to take those factors in play and to allow for an appeal system through that.
So would it still be the governor and would it still go to governor and council in the proposed system, or?
No, the proposed system is for it not to just to go to a governor in council, because then that would only be one stream, and that's actually not very efficient either in terms of dealing with that. So we're proposing what we call, for lack of a better phrase, I guess, the Carl recommendations, because the various different committees showed up, groups that showed up and offer a variety of different changes, and we put it all together, and the Canadian Association of Refugee Lawyers really combined all the different suggestions into one package, and then that package really enhanced what was before and brought in new provisions if the government adopts this in the fall, and to allow for better due process, to allow for a more streamlined process, and I think also a more efficient process for the applicants themselves as well.
Yeah, and there was another issue that I listened to some of the Sims hearings, and an issue that I thought you uniquely touched upon was language testing for citizenship. And there's been a little bit of a discussion over reducing the language testing requirement for citizenship applicants from, I think it's 64 to 55 in Bill C6. And you had some comments at the citizenship or the Sims hearings, and also I think in the media. I was wondering if you could comment on your thoughts on language testing for citizenship applicants.
Yes, essentially there are two sets of procedures that a person's got to go through in order to attain their citizenship. One is that you have to demonstrate your language to a level of proficiency that is required. And in my view, the current system as it stands, that level of proficiency is overly high, to be honest with you. A lot of the people would not be able to meet that level of proficiency. A lot of immigrants, I know my family, when we first came, we didn't speak English. And I'll tell you, if that level of proficiency was required at the time when my parents became citizens, they would have failed that test. And a lot of immigrants, when they come, people are just trying to survive, put food on the table to support their families. So they don't have time to go and get the level of proficiency that is required to pass the test. So I wanted to address for the government to acknowledge the difficulties around that and to allow for flexibility and to reduce the level of proficiency that they're requiring for to attain citizenship. Second, related to that, is basically amounts to double testing. And that is that when you're tested on your knowledge, that test is done in English. And so for a lot of people, again, if English is your second language, there are a lot of technical terms that you may not be able to say or even understand just because they're very technical in nature. And so we used to have a system where for people whose language is a second language, English is their second language, they would actually provide for translator on the knowledge test. That is now being done away with. And so it amounts to double testing for people whose English is a second language. So now I ask for changes with respect to that as well.
And so how many, in your sense, you talked about where the citizenship reforms are going. Do you think, it didn't pass before Parliament recessed for the summer. Do you have a sense of why that happened?
Well, it went through the House of Commons. It passed through third reading for Bill C6. So it's now before the Senate. And so the Senate, of course, is breaking for the summer holiday. And so they're not sitting, so they will not get through it in the summer. So I anticipate that will happen in the fall when they resume on Bill C6. I certainly hope that it will. And I hope that the changes that the Liberal government brought in will pass. They were good changes. By and large, they were good changes. There were a few things that I was not happy about. By and large, they were good changes. But they did miss a whole bunch of other things that they need to address. We talked about the due process with people whose citizenship is being revoked, for example. There's another issue which I find astounding that the government did not address in Bill C6. That is that if you're under investigation for your citizenship and your you're in that process, they could investigate you indefinitely. There's no timeline to restrict to say how long this investigation can go for, which to me is astounding that we would bring in a law as such for people. We have, in other areas in criminal law, you have 7 years in terms of your statutes of limitation, but here in immigration, you don't. If they're going to investigate you, you could literally die before you know whether or not they're going to pursue those allegations or not. So that's not, to me, appropriate. And so I think that needs to be changed as well. What Minister McCallum said to me and also at committee when I raised the issues around amendments that's required, in particularly the issue around due process for the cessation, or so for the revocation of citizenship, he did say that they would bring in new legislation, and that I expect will happen in the fall to fix the problem that the Liberals had missed under Bill C6.
So you expect there would be another more citizenship amendments to come in the fall, along with what we understand will be some substantive changes to the Immigration Refugee Protection Act as well. It sounds like are being proposed or are going to be proposed relatively soon.
Well, I'm hoping that they would actually incorporate something into the bill to address the issue of cessation, and this is particularly for refugees who's come to Canada, and for some of them, they have traveled back to their country of origin. And in that process, what the Conservatives have done under a separate bill, Bill C-31, was to bring in a process to revoke, to allow IRCC, immigration, to actually revoke your citizenship, revoke your permanent resident status and even your refugee status. And to me, that's quite something as well. This bill, Bill C-31, was brought in and it is retroactive. So that is to say, for a person who traveled back to their country of origin, at the time when they traveled, this law didn't exist. You had no idea that if you travel back to your country of origin, that you were putting your status in jeopardy. And that's what the Conservatives have done. And it doesn't matter why you're traveling back, by the way, your country of origin situation might well have changed. And that doesn't matter either. The fact that you travel back, you're already put yourself at risk. And often how people are flagged by immigration is because you're applying for your citizenship and they flag you, and then all of a sudden you find yourself in a whole whole situation where you have you're completely at risk. So I'm hoping the government actually will do something to address that issue as well.
So just to provide some context for listeners who are less familiar with refugee issues, the refugee status, when somebody obtains status as a protected person within Canada or from outside of Canada, they're also eligible to, or often are eligible to, get permanent resident status as well, but they're two different statuses. So you have two statuses, one being protected person status, the other being permanent resident status. And it used to be, cessation has always existed as part of refugee law, where you could lose your status as a refugee because you no longer needed protection. And up until 2012, you, by way of cessation, would lose your protected person status. But if you were also a permanent resident, you wouldn't lose your permanent resident status. And what's happened since 2012 is that when you lose your status by way of cessation under 4 of the provisions, so there's 5 ways of losing it, under 4 of them, you automatically lose your permanent resident status at the same time. And so that's the problem that you've been talking about. Now
To backstep even further, when we're talking about cessation, we're not talking about scenarios where people may have lied to get their status. That's a whole separate process called vacating of status or refugee status. Cessation means there's been a change in your country of, as Peter was saying, a change in your country of origin, such that you can be thought to have either re-availed yourself of that country's protection, which is where in the citizenship context you apply the citizenship checklist. To apply for citizenship says you need a passport. You apply for a passport from your country, and they determine that you've re-availed yourself. The legislation that the Conservatives introduced was when cessation would apply and you no longer need refugee status, that would, in cases of where you were found to have re-availed yourself of their protection, such as by going on a trip to visit that sick family member or by applying for the passport, that you would automatically lose permanent resident status. And there were people who I think had come even under Pinochet and had claimed refugee status dozens and dozens of years ago, hadn't achieved their citizenship, may have gone back to Chile, 20 years after they first came here. They ran a risk of losing their permanent residence. And it was controversial at the time. I know, Jenny, you have a private member's bill. I can't remember. It's Bill C2, Bill C...
They actually don't give you a number yet because it's a private member's bill, so it's C something, but it's kind of just waiting.
Okay, and so I have it printed a little bit in front of me, and it says the bill is to amend the Immigration and Refugee Protection Act to reveal provisions related to inadmissibility and loss of status resulting from the cessation of refugee protection for permanent residents. And the bill itself is it's pretty short, and it repeals both the fact that the cessation of refugee status will result in a loss of permanent resident status, and the further amendment that Bill C-31 had introduced, which was those people would also then be inadmissible to Canada. So do you suspect that this may be taken up by the government in their legislation?
I'm really hoping that the government will do something around these cessation cases. I brought this to both the minister's attention as well as to the parliamentary secretary's position information, and I've raised this in the House of Commons through a question period as well. We followed up with further debate around this, and every indication from the government side seems to be that they understand why I'm driving this issue and why the government needs to make the changes. When they were in opposition, when this was brought before the House of Commons, by the way, they voted against it as well. And this law, Bill C-31 on cessation, effectively, in my view, creates two classes of permanent residents. Those who are able to travel back to their country of origin without any repercussions, and those who could not. And so in this instance, if, Trudeau have said, our Prime Minister have said, a Canadian's a Canadian's a Canadian, permanent residence should be a permanent residence, should be a permanent residence. People should not be treated and penalized in this way. And why this bill is so offensive to me, or the cessation provisions are so offensive to me, is that basically the Harper government brought in a law that's retroactive. And they have no comprehension, it appears to me, about the circumstances of each and every case. People travel back for all kinds of reasons. And it may well be that your country of origin where you left is no longer a threat. And there was, in fact, a case as such, and it related to a person who is a refugee and left because of Saddam Hussein's regime. And of course, that is no more. He traveled back and visited. And now he's being targeted because of that. And that to me is just absolutely absurd. And so I'm really hoping that the Liberal government will understand that. They seem to indicate to me that they are supportive of what I'm calling for. And I'm hoping that in the fall that they will fix it.
And that is a second issue. I can't remember the name of the Federal Court of Appeal case, which says that in this whole process, a person's humanitarian and compassionate considerations aren't a factor that either the Immigration and Refugee Board or the Canada Border Services Agency is supposed to consider.
Yeah, we had dealt with those in both the Bermudez. Bermudez was the case in the Federal Court of Appeal. Olvera had been decided in the Federal Court. Ultimately, Ms. Olvera was able to keep her permanent residence as a result of cessation and other circumstances, and so we didn't pursue the case in the Federal Court of Appeal. But there were definitely some serious concerns in both cases. Mr. Bermudez has 3 Canadian children. He's has a Canadian spouse. He's well established here and went back to his country in 2009 for a very brief period of time. In terms of the critique from the Conservative government, and when it was passed originally, there was a lot of talk by Jason Kenney of bogus refugees. And so the example he gave and repeated over and over again was the person who gets their refugee status, gets their permanent residence, and 2 weeks later is on a flight back to Iran or is on a flight back to their country. Why should we let those people stay here? Why should there not be a process to be able to cessate their status?
Well, I mean, Jason Kenney, I'm sorry, raised this issue, and he's effectively trying to say that refugees are trying to cheat the system, and so therefore taking advantage of Canadians for accepting them as refugees. But I'll tell you this, first off, when refugees come into the country, do we actually say to them that when you accept our invitation for you to become a refugee in Canada, that you may never, ever travel back to your country of origin for any reason, whether that you have family members who've left behind that are dying, it doesn't matter. You are not allowed to go back. And if you do, you put your status in jeopardy. If we say that to people and then we follow up with it, so be it. But we don't say that to people. And people have extenuating circumstances why they need to travel back. We all have lives. We all are people. And those reasons need to be taken into consideration. And the Conservative government did not do that. Not only did they not do that for current refugees, they went retroactively back to go after people. So people, even at the time of the travel, when they traveled back, they had no idea that they would put their status in jeopardy. And that's what the Conservatives have done. And to the point where, through a Freedom of Information, we find out that they were targeting people. They want to achieve 875 cases each year by targeting people retroactively. And that, to me, is absolutely astounding. And that's what the Conservative has done. And the Liberals and Justin Trudeau said that they were different, that they were bringing real change to Canadians. And I certainly hope that they would take the cessation bill that I have tabled as a private member's bill and adopt it as a government bill. I would love it. Nothing would make me more happy than the government to adopt that bill as a government bill and to proceed with it, because that is the Canadian way. And what Jason Kenney and what the Harper government had done is absolutely, in my view, not who we are.
Well, I hope that I hope you're right, and I have to say that dealing with refugee communities is one of the issues that has definitely sown a lot of fear in established refugee communities, and some communities that I didn't even know existed. I was surprised to learn that there was an Achinese community in Vancouver, and the Achinese had come here during the Civil War in Indonesia. There were, I guess, a couple hundred government-assisted refugees at the time. The Civil War came to a rather abrupt end after the tsunami, when entire swaths of the province were wiped out, and many of them traveled back afterwards, after there had been a peace accord and in the many years since then. And there's a lot of fear within those communities because they're getting cessation letters, and they had been getting cessation letters. So that's just one of many communities that I have discovered through this program, call it a program campaign, which was rather unfortunate. So I hope that you're right that this does go ahead.
Mm-hmm. And by the way, too, I mean, for refugees too, right? And it was always understood that when they travel and came here, that because of the situation back home, and that some of them may well travel back, right? Because one always hoped that for the home country, for the conflict and the issues that are happening there would get resolved. Because moving people away from the home country was never the only means or even the preferred means of supporting refugees, because we want to try and sort of provide supports to their home countries for those conflicts and issues to be resolved. But now we also know reality is that oftentimes that doesn't happen. And so by allowing for a stream for people to come to Canada as refugees is to acknowledge that. And many of them do actually settle here. They have their roots here. They have families here. They're employed here. And they do all of those things and contribute to Canadian society. And that's fantastic. And that's what makes Canada, by the way, so great. We're a multicultural country. We're built on that as our foundation. That is who we are. We are the faces of the world, and refugees included. And we need to acknowledge their contributions to us. And yes, in the beginning, we support them because it was tough and they faced extreme traumas and hardships when they came. And once they've settled, they are part of our Canadian society. And to penalize them, to say that because they traveled back for whatever reason that they had a visit, that we're going to penalize them, is simply un-Canadian. It is not the right thing to do. And I'm ashamed frankly, of the Harper government for having done that. It's despicable, in my view, for having done that. It's an absurd law, and it needs to be repealed. And if the Liberal government says who they are, and they're going to bring real change to Canadians, I expect them to follow up and do that work. And that means they need to adopt the changes in my bill, adopt it as a government bill, or write their own bill. It doesn't matter. I'm not obsessive or possessive in that way, but just bringing in a new set of laws to fix the situation, because that cannot continue to exist.
So look forward to the fall. In the meantime, are there cases still being referred for cessation? Are they being actively pursued?
The cessation cases are being pursued. I haven't had any new cases come in recently. I've had a lot of people. There's still a lot of fear in the communities, though. I still do get a lot of people coming in to consult me. Can I go back to visit? Can I get, how's this going to affect me? Can I apply for citizenship and declare my travels? Can I get a new permanent resident card and declare my travels? So it's a serious concern, and it's an ongoing concern.
And active files are still going ahead.
Yes, they are.
Yeah. And I just I know of a case, for example, where the person at the time of travel, he actually went in to talk to Citizenship and Immigration and asked them if he could travel back. And then they said, yeah, as long as you have your PR card, you're good, go and do it. He did. And then now a cessation case is brought against him. I mean, this is how absurd this situation is and is ongoing. So, I mean, the real question is this. We are receiving some 25,000 plus Syrian refugees. Are people at the time when they arrive and land in Canada, when they accept the application, are we telling them that you can never, ever go back to visit your families ever again? I don't think so, right? We're not doing that.
And why would we tell them that?
Exactly. I mean, and by the way, our charter, of course, have freedoms and rights that are protected, and our right to have mobility is a key thing. And that principle ought to extend to everyone, including refugees who some may want to travel back to their country of origin for any reason.
So I think we'll move on to some news items of interest, or some new items in the news. Actually, this is not necessarily a new item. This is an item that's been around for a while. So we were going to talk a little bit about Rodney Watson, who is an Iraq war veteran who completed a year deployment in Mosul, Iraq, who's now living in First United Church in Vancouver since September of 2009. So he's been there for 7 years, almost 7 years now. Do you want to talk a little bit about Rodney's situation and what I know that you're familiar with his case, and maybe we can have you fill in the blanks here as to where what's going on there. Why is he still in this in sanctuary in the church?
Absolutely, Rodney Watson is actually a lovely man. I met him at First United Church, where he's seeking sanctuary. He is a war resister. He's a veteran. He served in the Iraq War, and then after his service, he was sent back. And when he was there the first round, and he witnessed a whole range of different issues, and he could not, in good conscience, go back to that war. So he refused, and he came to Canada and to seek refuge in Canada. And he's been at the First United Church for close to 7 years now. Come September of this year, he would have been at the church for 7 years. He's got a Canadian son. And a son that he barely knows because he can't step out of the front door of First United Church. And the Iraq War, of course, we now know that it is a war that is basically illegal. In fact, there was a recent report that was issued in the UK that clearly established that the Iraq War was really illegal, that action was taken before all peaceful measures were exhausted, that the threat was actually overly exaggerated and the risks overly exaggerated, and so on. And so you have Rodney Watson, and by the way, I think there are about 25 war resistors remaining still from the Iraq War here in Canada, from the United States across the country, and in various different provinces. And what we need the federal government to do is to tell the courts that they will not pursue the war resistors, that there will be a pathway for them to have citizenship here in Canada, to have status here in Canada. And I think that needs to be done. The Trudeau government, again, when they were in opposition, Olivia Chow, my predecessor, the NDP opposition critic, at that time tabled two motions in the House to call for the government to allow for pathway to war resisters. And the Liberals in opposition, including the Prime Minister, voted for that. Since the election, the Prime Minister had said that and criticized the Harper government for lacking understanding and compassion in their dealings with war resisters. So I'm hoping that the government will show compassion and understanding with the war resisters that are here, for people like Rodney Watson, who stood up on a principled stance, who showed enormous courage, in my view, for putting himself on the line here, for doing what he believed in. And really, by doing that, he's risking his own freedoms. And in that process, I think trying to fight for freedoms for other people. And so I'm hoping that the Liberal government will take action. Minister John McCallum, during the campaign, said they would do something about this. And if they don't, then you have effectively Canada will be contributing to criminalizing war resisters. And I think that is wrong.
It is something that Parliament is going to, or the Department is going to have to do, because Canada's courts within the refugee context have pretty consistently found that general desertion or refusing to serve in the military does not constitute a convention ground for refugee status. For those who like to follow case law, the Federal Court of Appeal decision is ATES and Canada 8. Be the Minister of Citizenship and Immigration Canada. And so it's typically in the refugee setting only where the refusal to serve in the military or to go off to war, typically where it pertains, where the consequence, jail or other punishment in the military courts of the country, where the desertion pertains to conscription for a legitimate and lawful purpose that's conducted in a discriminatory way, or if the punishment for desertion is based in relation to an existing convention refugee ground, such as race, sexual identity, political opinion. So it's going to be, especially in the case of American war resistors, something where in the overwhelming majority of cases, I would think, Parliament would have to intervene, because the Immigration and Refugee Board is unlikely to find that such people qualify for refugee status.
Well, that's exactly the problem. And in fact, the Harper government brought in a bulletin, a special bulletin, Bulletin 202, that actually criminalized war resistors. So by virtue of that, people cannot apply for status really, because they would be deemed to be not have met the conditions. So that needs to be rescinded. Bulletin 202 needs to be rescinded by the government, and then a pathway needs to be available for those who are here seeking Canadian citizenship. And so I'm hoping that the government, in fact, will take action before September the 16th. And this is when the course is waiting for a signal from the federal government today on what they intend to do with this group of war resistors.
Do you see a limit at all to what you think? Do we run the risk of creating a system whereby in countries where there is the draft, Israel, Russia, Taiwan, South Korea, that anyone who comes from those countries to Canada can claim permanent residence by saying that they don't want to be in the draft, and that we create what could be a very big queue of people who just don't want to serve in their country's military as a pathway to permanent residence?
Well, we can certainly take a look at other cases, but right now we have the war resistors from the U.S.-Iraq war, which has been declared, by the way, I would say, a illegal war, and so we need to take action with respect to that. I would also say this in terms of the war resistors around it. Canada actually has had a huge tradition, to which I'm very proud of accepting war resistors and dodgers. The Vietnam War, by the way, at that time, we accepted, at least 50,000 people. Some say 100,000 if you include the Dodgers. And so there were a lot of people to which we accepted, which, by the way, in British Columbia, we should be so proud of this. Dr. Michael Kwan just recently received a Order of Canada recognition, and he was a war resister.
Jim Green also was?
Jim Green, my former mentor, the late Jim Green, was a war resister. And you know what? In this province, in this city, he transformed a city. He was such an enormous voice for those who are homeless, who are marginalized in our community. In fact, I think he became one of the largest developers of nonprofit housing, in building housing to house those who are homeless, people who wouldn't otherwise have safe and secure, affordable housing. That was Jim Green, a war resister. They contribute enormously to our communities. We welcome them, and they are part of us, And so now we have a small group, 25 of war resistors left here from the U.S.-Iraq war, and their lives are in limbo. They do not know what's going to happen to them, and they have no future unless if we address this. And I'm calling on Minister John Callum and the Trudeau government to take action before September 16th.
So, I'm glad that you were able to join us this week. We've surprisingly, Parliament's the Standing Committee on Citizenship and Immigration has actually been quite busy over the summer. Normally, you don't sit during the summer, but you have been sitting over the summer. What have you been studying? Or do you want to just give a brief outline? I think we talked about it briefly in a previous podcast, but.
Yeah, we had a major issue that was brought to us at committee, to which every member, government and the two opposition parties supported the motion to study this, and that is the vulnerable groups that needs immediate action and support in the global universe. And so we studied, amongst others, but Yazidis who've been declared a genocide is happening against the Yazidis community. And that has been declared by both the UN and by the government as well, the federal government. And so with that backdrop, urgent action was needed for government to do something. We know that there are thousands of Yazidi women and girls who've been enslaved, who've been raped and tortured, and that are still very much at risk. Some of them, even at the refugee camps, are still at risk. And so we wanted to look at the vulnerable groups and to see what action can be taken immediately. So over the summer, we came together with this emergency resolution. And we heard from a whole variety of different witnesses that gave such compelling and moving testimonials at the committee. In fact, more specifically, there was a survivor, a young woman who escaped and survived and came to Canada, and she told her story. Yazidis young woman, she told her story, and it was just heartbreaking. Not only for every time for her to tell their story, she's reliving it, but also to know that there are people that are still in that situation right now. And basically, she is advocating for change in the global community, in Canada included. And so coming out of that set of committee meetings, I wrote a letter to the minister calling for basically 5 things that I think we can do over the summer as emergency action. And one of them was to work with organizations, nonprofits on the ground who have already identified the women and the victims of the genocide and to provide a pathway for them to come to Canada immediately.
That was point one.
That was point one. I can go. Yes, I mean there.
The other 4 points?
Yes, and so the other 4 points. We also know that other vulnerable groups include, for example, the LGBTQI community, and in some countries, at least 63 of them, they declare it to be illegal for you to be gay, for example, and there are people who are just stuck in these situations and their lives are at risk for no other reason other than for being who they are. And so I wanted the government to take action with respect to that, and we can actually move forward with a pilot project to bring back a category of application for people who in their own countries, in their source country, to make an application as a refugee. Because right now, as it stands, our refugee laws do not allow you to make application if your source country accepts you, right? So then they're not deemed to be at risk in that way, with exception that for LGBTI community, they're exactly at risk. And so that source country application, I think, needs to be brought back as a pilot initiative to provide a pathway of support and safety for the LGBTI communities. So that's the second suggestion. The third suggestion that I made to the government has to do with refugees in northern Iraq. Right now, we actually don't even have processing centers in northern Iraq, and people that are there are at extreme risk. Even though they have been approved by the UNHCR, they cannot get to Canada, even though they have private sponsors all lined up here in Canada and ready to receive them. Even though they are travel ready, they cannot leave northern Iraq. Why? Because Canada can't get anybody in there to process their applications. And so I suggested some months ago now to the minister that why don't we use international agencies such as the UNHCR, such as the IOM, for example, to process these cases, because they can get in and out and they've already have people on the ground in northern Iraq. The government, the minister responded to say he thought that was a great idea, wonder why they hadn't thought about it, so they wouldn't get onto it. Still hadn't happened. And people are still stuck there and their lives are still at risk. And for Vancouver in the Lower Mainland, I know there are at least 100 families who's already found sponsors ready to receive them, and they still can't get here. So I call on the government to actually do what other jurisdictions are doing, and that is to allow for these families to come based on the UNHCR processing. And if they have done the processing and they've done the security checks and they've done all of that stuff, for us to accept that and to allow for those families to come. And other countries, by the way, are doing that when they're faced with those kinds of situations where they can't easily get in because of security measures, amongst other things, and they can't do the processing on their own from the sponsoring country. That's what they do. And that's the best practice in terms of the global community's best practice. So I'm urging the government to take that action now. We don't have to wait until September or later on for the government to try to do something, but rather over the course of the summer, we can in fact let those families come when they are travel ready. They have already been approved by the UNHCR, and we have sponsors already to receive them. The fourth point in terms of action from the government, what I wanted the government to do on this question around source country, there are a whole great many other vulnerable groups in different places that cannot make application here because they cannot make application from their source country in that sense, right? So that class, we used to, by the way, had the source country class in place. Now, there were problems with it. I get that. And so the government, the Harper government did away with it. And supposedly the Section 25 under humanitarian compassionate section that was supposed to replace the source country class, with the exception that it didn't do it very well. And so now we have a situation where you have a number of different people, vulnerable groups in different countries where they can't access and come to the country because of that limitation. So I'm asking for us to study this issue. And to look at what the problems were more clearly under the source country class when it was in place, and to work with the government officials in identifying the problems and then understanding the replacement and where the deficiencies are, and to come up with a new source country class to address this problem. I think that's a worthwhile project for us to do. And again, for Canada to say that we are different from the previous government, that we will engage in such a way that will, I think, reclaim our space in the global community of showing the kind of compassion that Canadians are all about. So that's another recommendation that I made to the government with respect to my letter. And the last but not least action dealt with, oh my gosh, what was the last thing? Sorry. Okay, let me just regroup here. The Yazidis issue and the issue around Northern Iraq, LGBTQI, and the study. And the fourth one.
It is four.
sorry, the fifth one. There's one more. Let me just think for a minute. So the fifth issue is around humanitarian aid. At the committee, it was quite something, and we heard from witnesses who came to present to us to tell us that the humanitarian aid are actually not reaching the people who are in greatest need because of issues around corruption and discrimination, amongst other things. And their ask was a very simple ask. Basically, they're asking for the aid to be distributed by a reputable organization here from a team from Canada. So, for example, Red Cross would be able to do that, to actually distribute it and make sure that that aid go to the people who are in greatest need. And it's and what are they asking for? Basic provisions, such as oil, flour, and rice. So not anything extravagant, but something to provide sustenance, if you will, for the people in these camps and who are just absolutely starving. The other example that they gave would be that for some families where they're able to go and make their own purchases for cash donations to be made available to them, $200 would mean a world of difference for these refugees, and that they would then be able to buy clothes for their children, for example, who's been in the same clothes in the camp for more than a year, for example. So these are just very basic things that they're asking for. And there are teams, nonprofits on the ground who's doing this work, by the way, in these countries, in Syria and amongst other places, and they can work with our international teams. And I'm really hoping that the government will respond to that. The government, by the way, and kudos for the Canadian government, and I'm proud of us for doing that. We have just, by the way, increased our humanitarian aid in the international community. There was an announcement of $150 million with respect to that. So we can take some of those resources and actually direct it in such a way to make sure that it reaches the people and that are in greatest need, and that the issues around corruption, discrimination, and what have you does not run interference.
Yeah. We talked about it last week, this issue of prioritizing certain refugee claimants or resettled refugees over others, and how complicated an issue it was. I still don't know where I fall on it. As I read the transcripts of different witnesses opining one way or the other at Sims, I'd find myself reading somebody who said that we shouldn't prioritize groups and think, oh, that makes a lot of sense. And then the next witness would give the complete opposite opinion, and I'd think, that also makes sense. Have you formed after all those hearings an opinion one way or the other? Or?
Yeah, I think you're right. I mean, people have compelling reasons to advance the position that they have brought to the committee. And I would say on the whole, I would say all refugees are the same. And we need to acknowledge that by virtue of the fact that they're refugees and they're seeking asylum is because their lives are at extreme risk. There's no question. And that is something that I acknowledge and absolutely accept. In this instance, why I'm calling for certain provisions to be taken more immediately. Well, in the case where there is an acknowledged genocide, I think it puts it in a different realm. You have a situation where a community of people, for whatever reason, and in this instance, it happens to be religious beliefs. It could be for any other reason, right? That you as a community are under such target that your race would be exterminated. Really, if action wasn't taken, this is the intent behind the genocide, right? So I think that calls for extreme action, and that, I think, is sufficient for us to declare that we need to prioritize this group because there is a genocide going on. And I fully accept that and would advocate in moving forward for the government to move forward with respect to that. The other group that I have sort of advanced are the LGBTI community. These are individuals who are criminalized in their own country for being who they are. And if they're outed, they will be in the minimum jailed, if not killed. People have told me stories, the Rainbow Refugee folks who've done tremendous work around this in our community know of situations where people have been stoned to death because they are gay. This is happening, and that to me puts them again in a different realm. Not to minimize the urgency for all the other refugees and the importance of that, absolutely not. But that puts them in a different realm when they're at that level of risk. And when people make an application, by the way, when you're LGBTI you're an LGBTI community member and you make an application, they are so worried that if somehow they're outed, that they be dead before the application is even processed. And those delays in the application of processing, they're at extreme risk. There are some situations where people in their home country, where they've been outed because they made an application, they flee to another country and it's just as bad. And they're waiting there, hoping that nobody will know that they're there and that somehow they can just manage and get the applications through without being assaulted in a major way or losing their lives. That, to me, puts them also in a different realm. And so that's why I'm calling for a pilot project with respect to the LGBTI community to see how this works and how we can address these issues more appropriately. But in the case of a genocide for any community, I think that we need to do what we can immediately. And Canada, by the way, is also signed on to the right to protect as well in the global universe. And that calls for action, and we can't wait.
We'll move on to a case turning from refugees to general status in Canada. It was a case that I know at our office, as soon as it was released, caused a fair amount of, frustration as the federal court answered a question that has been left silent for a while, but I think people were hoping for a different result. And that involves whether the Canada Border Services Agency can remove people during the restoration period and after they have filed a restoration application. So before I explain that a little bit, I'll just give the case name. It's Ouedraogo and Canada Public Safety and Emergency Preparedness. The spelling is Ouedraogo, and the neutral citation is 2016 FC 810. And so when somebody is in Canada on a work permit, a study permit, or with visitor status, and they forget to extend their status prior to expiring, they are then without status. The Immigration and Refugee Protection Regulations provide that if somebody applies within 90 days to restore their status, that Immigration, Refugees, and Citizenship Canada will restore their status. So there's what's often colloquially called a 90-day grace period. And people have referred to it as a 90-day grace period, even though the question of whether somebody can be removed during that time has never actually been resolved by the courts. So in this decision, Madam Justice McVeigh weighed in for the first time on the issue. The case actually involves a high school student who forgot to apply to extend their status in Canada after graduating from high school here, was scheduled to start at Langara, and was detained at a traffic stop and issued a removal order. And she filed a judicial review with the federal court. The issue before the court was whether during this 90-day period, the Canada Border Services Agency can remove people, and Madam Justice McVeigh said that they can. And in reaching that decision, she also found that even the filing of a restoration application does not prevent the Canada Border Services Agency from removing people. So in response to the submission that the immigration law says that people have 90 days to apply to restore their status, it would be seemingly contrary to the purpose of that provision to deport people or to issue people exclusion orders during that time. The justice said that this interpretation would have the effect of automatically extending the time for which a temporary resident is authorized to remain in Canada by 90 days, and that cannot be what Parliament intended. And I know that this decision has taken a lot of lawyers by surprise, who have always considered there to be that 90-day grace period, and in some cases would advise people to not necessarily even apply right away to try to buy time for, say, in the foreign worker context, an employer to get a labor market impact assessment. This would immediately cast doubt on that type of advice, and even whether somebody who is in Canada without status, at a minimum, they need to be told that just because they file for restoration doesn't mean they're going to not be removed from Canada during that period.
I guess I'm surprised that a lot of lawyers are surprised by this, because you need to spend a lot more time with the CBSA to. But for me, it's actually not a surprise, because what the applicant did in this case was very different than. And there's an old case called U that was the basis upon which this understanding had always existed.
And in that case, that's 2005, where they said that somebody who has filed restoration can't be said to have been breach of the Act, and therefore couldn't be removed.
Right, but you look at the difference between the two cases. So what Ouedraogo does is he gets picked up, he goes in, he gets told by CBSA, they find him as an overstay, and then he runs off and files a restoration application. That's exactly the way CBSA has been dealing with this in this way for years, right? If you get caught before you've filed your restoration application, they are going to proceed with the exclusion order. You don't get to run off and file your restoration. It's not a 90-day grace window. It's not a 90-day implied extension on your status. What Miss U did, and if you look back at the U case, was there was a 90-day grace within the 90-day period, right at the beginning of the 90-day period. He or she, I forget if it was a she, but I think it was a she, went off and applied for the restoration of status. And then 2 months later, CBSA, she comes to the attention of CBSA, and CBSA is then told by the federal court, well, you can't go after somebody after they've applied for restoration of status well within the time frame. And in my experience with, if you apply even right at the end of the 90-day grace period, so if you're right at the end of the restoration status, and then 2 months afterwards, CBSA, you come to the attention of CBSA, they don't pursue exclusion orders at that time. What we find in this case, and I think is the same advice that we have in any event, is that if you apply within the 90-day grace period and you apply before you come to CBSA's attention, then there will be a grace, or in general, they will exercise their discretion not to pursue. And arguably, U says they can't pursue an exclusion order, because the whole point of having a restoration provision within the Act. That being said, it's not a guarantee, and it's not the same as implied status if you apply when you're supposed to. And the safest thing is to make your application before your status expires, and then you get implied status.
I think my problem in part stems from the fact that the IRC, when they refuse a temporary resident extension application, and there's some inconsistency on this, but I would say about 90% of their letters say, your application for a work permit has been refused. You have 90 days to apply to restore your status. They don't say anything in there, oh, and by the way, we may remove you during this time. And I think those letters gave rise to this understanding. And if I got a letter like that, I would think, oh, okay, I have 90 days to apply to restore my status. It says I can't work, but surely if they're giving me 90 days to restore my status or apply to restore my status, they're not going to remove me during that time. And I find it like the whole notion that we would operate, that they can operate on parallel streams. I think that the laws need to be interpreted in a manner that assumes that the Canada Border Services Agency, especially once exit controls come in, will immediately be able to know when people have overstayed and act. And the interpretation that they can operate in parallel streams kind of assumes that the Canada Border Services Agency can't track overstays and won't find overstays.
Well, I mean, in the end, the law's been written the way it has. It has a restoration period which is different than implied status, and ultimately, implied status and restoration function differently. The practice of not going after people once they've applied for restoration within that period, I think, is consistent with the Act, in the sense of saying, look, you've got this provision within the Act, and that's what the court said in you, is that you have this provision within the Act. For it to be meaningful, once people have applied for restoration, if they've done it within the period, then you shouldn't go after them. The idea that you wait...
does get qualified in Ouedraogo.
Well, what Ouedraogo, I mean, my reading of Ouedraogo, and I think it's limited to the facts in Ouedraogo, is that you can't wait until you come to the attention of CBSA and then run off and do a restoration application and hope that they're going to leave you alone. And that's always been my advice to clients.
Yeah, I mean, I would now, as a result of this case, go further and say, don't assume that the filing of the restoration means that they can't still remove you. It's a factor that they have to consider, but it's not preventative. until there's further clarification on the issue from the federal court.
All right. In the last case we want to talk about this morning, the BC Supreme Court made a rather unexpected decision, staying the proceedings in the Nuttal case, which was the legislature bombing case, finding that there had been entrapment, and this is the terrorism case. There had been a long investigation by the police against two, it sounds like drug-addicted, mentally ill defendants who were pushed into a conspiracy based on the court findings. In any event, the last few paragraphs are quite damning of the police investigation in this case. Although there's no finding of bad faith, the court definitely finds that the actions of the police were what created this supposed terrorism conspiracy in the first place, and ultimately stayed the charges, which is a rather drastic remedy from the court's perspective. It's also an interesting case in the context of a lot of civil rights groups in the United States alleging that a lot of the investigations by the FBI and other police or authorities in the United States were along similar lines, and there have been similar allegations in the United States and elsewhere with respect to these types of investigations. So we're hoping to maybe we'll be able to talk about this a little bit with Marilyn Sanford, who was counsel on this case. We're hoping that she's coming to join us soon on the podcast. She was going to come and talk with us about border searches, but at this point we'll hopefully be able to have a chat. We'll add this to the list of things to talk with her. So, did we have anything else, or is that
Pokemon Go?
Pokemon Go, go ahead.
Oh, you got it.
This
was your article.
It was my article. Well, so there was as a last, rather, and I would say entertaining only because a lot of the kids, for those of you who have kids, are already familiar with Pokemon Go and are out there trying to catch.
I organized a Pokemon Go bachelor party. Not like we replicated it. We actually went into Gold. The person whose party it was wanted to play Pokemon Go, and I had none of that. So we went into Golden Ears National Park where there's no reception. We had hid some Pokemon dolls in trees, gave him lacrosse balls that were painted the colors, and he had to lob them at the trees. So it's not just kids.
And did you put any of the Pokemon on the other side of the border?
No, but and that's what happened here. But had I, no, because I hadn't even crossed my way.
So I guess a couple of Pokemon players were quite actively chasing. I would hope a very rare Pokemon that was worth catching, because so they crossed the border to catch the Pokemon. And so for all of you out there in the augmented reality, it might be worthwhile to augment your reality with some of the lines that still remain relevant in the actual world, in terms of the lines in the sand, so to speak, that one might not want to cross without going to a border crossing.
It'll be interesting during question period when people are on their phones to be wondering, like, what motion are their thumbs making? Like, are they playing Pokemon Go right now?
Well, I'll tell you this. I mean, it's become a craze, and I've got kids, so they're obsessed with it, and they bugged me for days and days and days until finally I gave in and got this Pokemon Go business going for them. I have to upgrade my daughter's phone. Good grief. And her phone was really only meant to be a safety net so that I can locate her, a 13-year-old teenager, so I can find where she is. But in any event, enough about my problems. But Pokemon Go, I got to tell you this. People are obsessed with it, adult, children alike. And I took my kids to Stanley Park. Apparently, if you're crazy about Pokemon, that's the place to go, because there's water Pokemons and forest Pokemons and what have you. It is all over Stanley Park. And but one thing that's interesting, that I wonder how this is going to play out. As we know, smartphones, people are busy texting and doing all that kind of stuff. And you're not allowed to drive, of course, texting and so on. That's already been a law that's been made around distracted driving. There are issues around distracted pedestrians. And so with Pokemon Go, so hot with people already, people are just busy talking and texting all the time, walking into trees and cars and what have you. What will happen with Pokemon Go? I wonder how this is going to play out. And I think it's going to prompt some very potentially legislative action with respect to restricting pedestrians in their use of smartphones.
Well, let's look forward to the Pokemon Restriction Act.
We'll see how that goes. That's not going to be popular.
Hey everyone, Steve Mearns here again. I hope you enjoyed today's podcast. Once again, you can find a link to this podcast, a link to all the cases referenced, as well as previous podcasts at borderlines.ca. That's BORDERLINES.ca. Thanks for listening today.